Good afternoon. Welcome, and thank you for joining us for this afternoon's webinar on returning to work, what every corporate counsel needs to know today. I'd like to begin today's webinar with some comments provided to us by Marvin Genzer of the Research Triangle chapter of the ACC. On behalf of the Research Triangle chapter of the ACC, thank you all for participating today and for your understanding of our decisions regarding 2020 programming. As you should have seen, all in-person events for 2020 have been canceled, including the 2 annual receptions, and we have postponed the Biennial Institute until February 2021. Like today, we hope to maintain our published program by webinar and are currently working with our sponsors on scheduling. Stay tuned for upcoming events. If you have opted out of receiving community correspondence from ACC, you might want to reconsider, since we'll be using that system for communications in lieu of CBIT for this year. As a reminder, the NC State Bar recently revised its criteria for CLE to permit all required CLE to be obtained online. We want to thank Gordon Smith for today's timely event and look forward to the remainder of the year with webinars. Marvin, thank you so much for providing these comments. Before we begin the webinar, I would like to take a moment to introduce today's presenter, Ken Gray of Gordon Smith. Ken's practice experience encompasses various areas of employment-related litigation. He advises clients and litigates cases involving all forms of employment discrimination, wrongful discharge, and breach of employment contracts, from small startup companies to Fortune 500 corporations. Ken is a frequent lecturer on employment discrimination, workplace retaliation, workers' compensation, and wage and hour law issues. Again, thank you so much for joining us. Before we begin, please note that Ken is going to utilize a few PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both his video and slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose side-by-side mode. The slide deck should appear on the left and Ken's video should appear on the right. You can then slide the separator to the left or the right to adjust the size for your view. If you have any issues during the webinar, please reach out via the Zoom Q&A feature and we'll try to troubleshoot with you. I'll turn the mic over to Ken and we can begin.
Good afternoon. Many of you on this call have heard me speak on one or multiple occasions, and the last time that we were all together, I think things were quite a bit different than now, and I think it's fair to say that we're in uncharted territory. As lawyers, most of us are not accustomed to dealing with a lot of medical issues, but we're having to deal with science and medical issues that we never thought we would ever have to address. And I have a good quote from Hannah Gordon, who is the general counsel of the San Francisco 49ers. And she said, quote, "If you would have told people a year ago that we would be taking temperatures before allowing people to enter a workplace, we would have thought that was ridiculous." She said, "But now that's a standard practice." So yes, we are in uncharted territories, and we are operating in a world that is completely different than ever before. Most of you who have seen me before know that I like to do live action role plays, or what we call LARPs. We're not going to do that, a full LARP session today, but we did have a real life scenario that we wanted to present. So I'll get Jen to read the first scenario, and then I'll talk about it.
Okay, great. Thank you so much, Ken. So for our first scenario today, we're going to present you with a set of facts. You are a general counsel for a manufacturing company that runs several production lines. Your company has followed all COVID-19 precautions recommended by the CDC, including temperature checks, increased cleaning and sanitation, and shields between stations. On a Friday afternoon, you get a frantic call from the company's HR director. She says that they had a line walk off the job today without notice. Production is shut down and needs to be back up and running ASAP. An employee's family member was diagnosed with COVID-19. This employee worked on a line that was shut down to properly sanitize, and employees on that line were sent home. The employees that walked out on the job worked on a different line. They were misinformed and thought an employee who worked on their line had been diagnosed with COVID-19. When they walked out, they indicated that they would not be coming back to work the next day. As General Counsel, how do you advise your management team to handle this situation? Please type your thoughts in the chat box.
So let me tell you about this story. This actually happened. These are the type of facts that are occurring on a daily basis. We got this call from a company Friday afternoon, right before typical closing time, and this is a household name company. I mean, if I were to say something like hot dogs, you would probably say Oscar Mayer. If I were to say something like tissues, you may say Kleenex. Well, if I were to say the product that this particular company provides, everybody would pretty much know who I'm talking about. And obviously I cannot disclose that, but I will say that this was a pretty frantic situation where right before quitting time, employees, based on a rumor, well, the real fact is that an employee on one line had a family member who just got notified by the health department that they tested positive for COVID. The company immediately shut down that line and sent the employees home, and were starting the process of properly sanitizing it. But then employees on a completely separate line misinterpreted the information and thought that one of the employees on their line, line number 2, had tested positive. And in mass, this was in excess of 30 folks, walked off the job before quitting time and indicated that they would not be back Saturday. And this is a company that has not been affected whatsoever by the pandemic. They're running 6 days a week, Monday through Saturday, full shifts, and they're putting out just as much product as they possibly can. And they need everybody to be working. And they were frantic because people were saying, we're not even coming back tomorrow. And so what do you do? As General Counsel, what do you do in that situation? And what we ended up doing was communication. That is the big thing. You're going to have a lot of people with fears out there. Some of them are well-founded, some of them are not well-founded. And what we need to do is clear up the things that are not well-founded. And so we basically did a thorough sanitation or sanitizing of the workplace. We informed the employees of all the safety measures that had been put in place, frankly, more than would even be required by the CDC, and gave them appropriate information and told them that we expected them to be back at work the following day. And that went out in email communications, and phone calls were made by supervisors to employees to make sure that the message got out there and that people were expected to be back on the job. And in fact, that did work. Nobody got a disciplinary write-up because of this. And so we were able to diffuse that situation and get the people back at work the next day and get the necessary production line operating. And the employees on the first line that had the company had shut down, they were able to return as well. And so just by clearly taking affirmative steps and clearing up misconceptions, the company was able to avoid a very damaging hit to its operations and to avoid potential adverse employment actions that would have most likely resulted in litigation, because what we're looking at in that situation is employees who are complaining about safety concerns. And there are various protections for those type of employees. When one person is complaining about a safety concern, North Carolina's REDA law, R-E-D-A, Retaliatory Employment Discrimination Act, prohibits an employer from taking an adverse action against that employee because they have voiced a safety concern. If multiple employees are voicing safety concerns, then we also have to be concerned about the National Labor Relations Act, which allows employees to communicate together in a concerted effort to address work conditions. And it has significant protections in place. And just because I said National Labor Relations Act and you're not a union, an organization that has unions, don't close your ears, because the NLRA applies to every private employer that's on this call. Not the public employers, but the private employers are covered by the NLRA, regardless of whether or not you have a union. So this law does apply to you. So we definitely need to address these issues, and I think there may be questions about this going forward. So we'll move on to the next slide.
So we did have some questions. So we did have a few questions, and we're going to do the next few slides in a Q&A style. The first question is, as COVID-19 contact tracing apps become available, can an employer condition an employee's return to work on the employee using such an app?
I suspect that just like the San Francisco 49ers general counsel, none of us would have ever thought a year ago we'd be talking about tracing apps. There are certain concerns that relate to tracing apps. We certainly have ADA and HIPAA concerns. For example, if an employee, we're tracking an employee who's going to pain management or getting their methadone medication, and that information gets out, that's problematic. But I don't think that would surprise anybody. You have to also think about privacy concerns, and certainly for governmental employers, this would be not a well-recommended approach because there are certain constitutional and privacy laws that are applicable here. However, for private employers, non-governmental employers, as long as there's not a state law that prohibits this, there is no federal law that would prohibit it. So in North Carolina, you absolutely can require a tracing app be used by employees. Then there's certain practical issues that are applicable, but there are already employers who have GPS tracking devices on trucks, and any certain employers that have anybody driving on for work-related reasons could have a GPS tracking device, and so that's already out there. The concern would be if you're able to articulate the legitimate business reason for doing so. And under the ADA, one legitimate business reason is to prevent harm or the threat of a harm within the workplace. And certainly, and the EEOC has recognized that COVID-19 is a harm or potential harm to the workplace. And so it would not be a violation of the ADA nor any North Carolina state law for a company to require a tracing app. You just have to, you need a policy about it, and you need to just have a uniform approach to doing it and be able to state a business reason for doing so. But that is a legitimate request at this time.
The next question is, Are there jurisdictions requiring employers to provide masks to office employees who will not have face-to-face interactions with customers or the general public?
Well, the bottom line answer to this question is yes, there are jurisdictions that require that, but they're doing so based upon a governor's or a mayor's or a county government's stay in place order, or the lifting of an order, but giving the conditions for the lifting of such an order. And in some of those, these are in other states, and we do have many in-house counsel who are multi-state, a part of multi-state employers. There are states in which, in certain jurisdictions, it is required to wear a mask in the office, regardless of the particular business that you're in. Some employers are requiring it, and that is perfectly fine. I know that, for example, my wife works at a hospital, and she doesn't have a face-to-face interacting job with patients, but everybody in the hospital, notwithstanding what their position is required to wear a mask at all times in the workplace. So we are seeing jurisdictions outside of North Carolina require people to wear masks, and certain companies in North Carolina are requiring it. So, but right now, there is no governmental requirement that I'm aware of in North Carolina that requires the mask. But when we get to phase 2, we're currently in phase 1. Phase 2, we may see some of that come about, particularly when you get to the companies that were shut down completely by the governor. For example, hair salons, massage places where you can get massages. Those folks that the governor said you cannot work right now, it is most likely that they will be required to wear certain PPE, including face masks, when they do get back open. And then certainly certain medical providers are requiring it within their own organizations.
And while you were answering that question, we did have a question come in live as a follow-up. If the company is not monitoring or accessing the tracing app, does that reduce risk of privacy or ADA concerns? What if our requirement is simply they download and use XYZ app on their personal device?
That is fine. And the thought process there would be, unless somebody indicates that they may have been exposed and thus need to get access to that information, we're not going to access it. That's kind of how I'm reading that question. Then that's perfectly fine. And as long as that information is not being accessed and you're not violating anybody's potential HIPAA rights or ADA rights, so that's a perfectly acceptable way to treat that tracing app issue.
Okay, and the person who asked the question said, yes, thank you so much for that clarification. Moving on to the next question.
You're on mute. You may need to repeat what you just said about the person that did that question.
Give me just a moment, y'all. Let me fix my screen here real quick. And it looks like we had a question come in while we're waiting for me to fix my, there we go. So the next question is, in jurisdictions where masks or face coverings are recommended but not required by law to be worn in office settings, is there potential liability if an employer, A, does not make masks available to employees in the office, and or B, allows employees or visitors who are not wearing masks to be in the office?
The simple answer to that question is yes, there is potential liability. I think it will be a best practice to have masks in every location where you're dealing with any visitors, and certainly you should allow folks to use the mask if they so desire. But I think it's also going to be a best practice for companies when they can get their hands on it to have masks available or other face coverings for folks to use. And we'll get into some policy and best practice issues later on. But the answer to this question is yes, there is potential liability.
Okay, thank you, Ken. And we did have another question come in live just a moment ago, relating back to the LARP scenario. What would be your recommendation if employees still refuse to return after being reassured that their line was not involved?
And that is a question that I know there's a later question in our slide deck about, but I'll go ahead and address it. It's going to be very similar to dealing with the ADA when somebody requests an accommodation due to a medical situation. And typically, we think of people having actual disabilities when we're talking about the ADA or some type of medical condition. With the COVID-19 situation, we may be talking about folks who don't have any medical situation whatsoever. It's just fear. We're still going to need to go through the interactive process and address it. And so step one would be to take necessary actions, such as making sure that the area is as germ-free as possible, communicating that and all the other safety measures that have been implemented to the employees, and then and say, we expect you to be back. And if they say, I'm still not comfortable, I don't believe that we're safe, then you need to get them to explain why. And you go back and forth, and it's best that this process be documented, each step of it be documented in writing, and get the employee to flesh out why they do not believe that it's safe, and you try to refute their concerns, and you do as much education as you can with that individual. And at some point, we get to the step where their fear just simply has no foundation whatsoever. And at that point, we may be able to take action against that employee, some form of discipline, potentially all the way up to replacing that individual.
And two questions have come in, one related back to the mask. So it says, masks protect both the person wearing it and everyone else. Can an employer require everyone to wear a mask?
Absolutely. Okay. Yes. An employer can require and enforce that particular rule. And we'll talk about some of suggested practices going forward, but yes, you can mandate this particular obligation.
Okay. And going back to the ADA piece of your response a little while ago, so are you saying fear is something we have to accommodate under the ADA as if it were a disability?
I love that question. It is not clearly fear is not a disability, but it is something that would require us to engage in the interactive process so that we can alleviate it in the mind of a reasonable person. Once we have alleviated that fear, then we are safe to take adverse employment action, assuming that we can alleviate it. Now, if we have somebody that's 65 years old, is a diabetic and obese, perhaps they are on medication that compromises their immune system, then we may never be able to alleviate that person's fears. And frankly, those may be legitimate fears. And in that case, we may have to take additional action that is somewhat softer, okay? And so it may be that person, we're just going to put that person on leave without pay for some period of time, just so we can not have to terminate them, but we've got to get somebody that can do that job. And I was on a conference call this morning with a client, and basically there's a difference between a 35-year-old person who's perfectly healthy and somebody that's 65 years old with comorbidities. And so we do have to potentially treat people differently. And so with the 35-year-old, I may be more ready to pull the trigger and terminate at some point that I feel like we've alleviated all the concerns that a reasonable person would have. And with the person that has the comorbidities, I may be more inclined to not terminate and just give an accommodation of additional time off without pay.
Thank you. And before I move on to the next presented question on our slide deck, can employers that are reopening decide to not allow employees that have spouses or people in their home that are frontline workers, for example, doctors, nurses, restaurant workers, etc., to come into the office and work remotely for the time?
What the question is saying is, if you have an employee whose spouse is a frontline worker, can we require those folks to work remotely?
I think so.
If that's the question, yes, you can up to a certain extent. Certainly if they are willing to do that, then, and it's not going to affect their compensation, then that is a perfectly reasonable solution. If they need to come in to get the job done, though, that's a different issue, and we would have to tackle that with a different analysis. The ADA does not want companies to just assume that somebody has COVID-19 because they're in a certain classification. And if you'll remember back to Title VII, not only is it illegal to discriminate against people, as we all know, for gender, race, national origin, religion, age, but it's also illegal to discriminate against people who are associated with folks in those categories. Well, this would be the same scenario, that if you have people that are frontline workers that are in your household, you're associated with them. And now it's a different thing if they have tested positive or they're being tested for the virus and we may think they have it. That's a different scenario. Then we can mandate people stay home. But you can't just assume that somebody is in a compromised position just because they have somebody in their household who is a frontline worker. So I think I answered that question, but I did see a question about what I talked about earlier. Could that be deemed employment discrimination? And I really appreciate that question, because in my earlier conference call with a very large medical practice this morning, we specifically addressed that scenario I gave you, where I said, we're going to potentially treat a 35-year-old nurse different than we treat a 65-year-old nurse. And yes, you could have employees who are side by side and you're treating them differently, even though they're in the exact same type of job, solely due to what their demographics. And normally that's HR folks just, scream and run for cover when you start talking about treating people inconsistently with their coworkers. And I typically would do the same thing. However, let's say we're talking about a 35-year-old and a 65-year-old, or we could be talking about a man and a woman, or we could be talking about people of different races or different nationalities. And yes, could those discrimination claims be brought? They absolutely could if you treat people differently, as I talked about earlier. However, if you did what I suggested first, which is engage in the interactive process, and it is all documented in writing, then we'll be able to show why we came to this conclusion that we're not going to terminate this 65-year-old diabetic, and we're going to put them on unpaid leave, and we're going to give them a reasonable accommodation under the ADA that they don't have to come in and yet don't lose their job. Whereas the 35-year-old, we're going to go ahead and terminate that person because their fears are just unfounded, and they're healthy. There's no reason for them to not be prepared to do the job now that we've told them what measures we've undertaken. And so as long as our interactive documentation shows why we came to this decision, I feel like that will defeat any discrimination based on gender or race or national origin, because we have the documentation to show the legitimate business reason for taking this inconsistent step. We're in unique times, and frankly, all governmental agencies are trying to give employers as much latitude as possible so that they can be open and get work done. But that clearly is a situation where it should be guided by an experienced HR professional and or legal counsel to make sure that we have sufficient documentation to overcome any potential discrimination claim.
And before we move on to the next slide, we did have one more live question come in. How do you address an employee who does not return to the office because they're responsible for caring for someone else in their household who is high risk? The employee, him, herself, is not high risk.
Okay, I'm going to address this question just specifically as it's worded, and assume that the person is high risk, but that they are not infected, the family member or the loved one. There is no protection for that under regular FMLA because the person must have a serious medical condition that you need to take care of this person, unless their medical condition is such that it would traditionally trigger FMLA. So, I mean, if we're talking about somebody that's going through cancer treatment and they need somebody there, and that typically would qualify for regular FMLA, yes, that would give regular FMLA protection, and whatever your policy provides, that's how you would do it. Otherwise, the only other thing that could potentially be triggered there would be the Families First Coronavirus Response Act for a company that has less than 500 employees, and DOL, the U.S. Department of Labor, came out with guidance. In its fourth set of guidance, it said that not only is it that you could have COVID-19 or you're taking care of somebody with COVID-19, but it could also be that you're taking care of somebody who a doctor has said is particularly vulnerable. And those are the magic words, particularly vulnerable to contracting COVID-19 and having serious consequences. In that situation, you potentially are triggering the 2 weeks of paid sick leave, not the paid FMLA, but the paid 2 weeks of sick leave. So that's a situation you have to look at carefully. But generally, that person is going to need to be back at work. And again, we go through some education and find out what their situation is, and it may be we end up having to replace that individual.
And I think that's a good transition into the next slide, which is, is there any specific guidance about standards for evaluating whether an employee is disabled under the ADA, such that the employer must continue to allow them to work from home after the lifting of state-mandated stay-at-home restrictions? Specifically, in a situation where the job duties truly require some on-site presence, how does the employer address an employee's claim that they wish to remain working from home because of various, assumed legitimate, health conditions that increase their personal risk in connection with contracting COVID-19?
Okay. Just to try to shortcut this question, the bottom line is if you can allow the person to work remotely from home, you probably should do so, particularly if they've been doing it up to this point, because that's evidence that it's not an undue hardship. However, this question specifically says that there are certain required things that the person needs to be at work. in that situation, and unlike any other situation, typically if somebody had asked me this question, say 4 months ago, I would have said that person can't do the essential functions of their job because there's a part of that that requires them to be at work, the work site. However, again, COVID-19 is a once in a lifetime situation. And we have set a precedence by allowing so many people to work from home. I might suggest to this person, depending on what the person's, and it says assume legitimate health conditions are, I might suggest that the employer allow this person to continue working from home, and we see if we can find somebody else to do the limited duties that are required to be in person at the work site. And again, this is not something I typically would recommend, but the ADA's definition of disability is expanded for COVID-19 purposes. And we really need to go through that interactive process that the EEOC wants to see. And if we get down to this point, it's going to be a game time decision. And the unfortunate thing is there is absolutely no bright line, no black and white answer here. Or how much interactive process do we have to go through? So it's going to be a case by case scenario, and depends on how bad the employee's health concern or legitimate health concern is, and how much they need to be at the office. If it's not that much, then we might be well advised to get somebody else to do that job. We have companies that are actually paying hazard pay to the folks that are able to be at work and do the extra jobs.
How about an employee that can't return because they don't have coverage for their child because school or camps are closed?
If this is a company that has less than 500 employees, then we would have to look at the Families First Coronavirus Response Act, and we potentially may have to do 2 weeks of paid sick leave and then an additional 10 weeks of paid FMLA under the Families First Act. So that is potentially the case, and we just saw some guidance that came down from DOL that addresses a great issue. I mean, school right now is obviously closed through the end of the year, which is typically beginning of June or the first or second week in June. But how about after that, when school is typically closed? And DOL said if the person's child care is not available, even though school is no longer an issue, then the person still can get the paid sick leave and paid FMLA. So but that's only for companies that are less than 500 employees, and you aren't a small enough company to exempt out of that. Certain companies that with less than 50 employees can exempt out. Medical practices can exempt specific employees from being subject to the paid sick leave and paid FMLA. So there are certain ways to get out of it, but that's a situation we got to take a look at very carefully. If you're a larger company, in that situation, there's a job that has to be done. And if the person can't do the job, and you can allow them to use up their paid leave, but after that, you do have the option to replace them.
So the next question is, what precautions should we take as we bring employees back to work? Do we need a policy regarding COVID-19? And if so, what should that policy be?
Okay, I'm going to just go ahead and cut to the chase. You absolutely do need a policy, okay? Some of them are called social distancing policies, but you need a COVID-19 related policy that addresses social distancing, that addresses any things that are prohibited. for example, if you have certain conditions, fevers, you're coughing, whatever conditions you define, then you're not to come to work that day. You must call in, you know, and then some companies are taking temperatures of employees. The first thing I did when I walked in the office today was get my temperature taken by the folks that are charged with doing that. When I've gone into doctor's offices, the first thing they do is take my temperature before they even let me in the lobby lots of times. So temperature checks are best practices. Social distancing, we're not having folks congregate. We're keeping the numbers of people that can get together in a space to a very limited number. Those type things that you've heard about on TV are all very good things that need to be addressed. And typically the question I see is, well, how about if somebody is not, they're not wearing the mask or they're not social distancing? Can we take disciplinary action against them? Absolutely. Because this is an employment policy that you put in place and you expect employees to follow.
And segueing from that question into the next one is, can we take employees' temperatures before they start working? Can we send an employee home who has a fever, symptoms of COVID-19, or who has potentially been exposed to someone with COVID-19?
Yes to all questions. You can take employees' temperatures before they start working. You can send employees home who have fever or symptoms of COVID-19. And if you learn somebody has been exposed to a person who is tested positive for COVID-19, you can make them go home and self-quarantine. And in that situation, if they do not have remote work to do, you can make them use PTO. If they do not have PTO and they're a non-exempt employee, you don't have to pay them for the time that they are at home. If they're an exempt employee and they've worked any portion of that week, you're going to have to pay them that full week's salary. But any 7-day work week in which they do not work, you're not obligated to pay them.
If we have employees who refuse to come back to work due to the fear of contracting COVID-19, what are our options?
And we pretty much addressed this one. You educate them on what you have done to show them that their fears are not substantiated. And you go through a process of trying to see if that alleviated their concerns and get them to articulate why it does not, and then see if you can continue to alleviate the concerns. You keep pushing back, and ultimately we're going to get to the decision of, is this somebody we're just going to replace altogether, or is it somebody due to perhaps medical reasons, comorbidities, that we decide we're going to just put them in unpaid leave status.
We laid off some employees, and those employees have filed for and are receiving unemployment benefits, including $600 from the federal government. If we recall those employees and they refuse because they're making more on unemployment, what are our options?
Okay. First of all, if they refuse to come back to work, there is no protection out there for because somebody is on unemployment, and you could terminate those employees. Well, what a good number of companies are doing, they're sending out notices to the employees and saying, we're reopening, or we expect you back at work on X date. And, you know, they're explaining any changes that will occur, or they're saying your employment benefits will be reinstated, you'll have the same seniority. And then it says, are you going to be able to come back on that date? Yes or no. And then it says, if you say no, then we're going to notify the unemployment that there's a job available for you and that you have refused that, and we will have to replace you. So there's A and there's B, and then there's actually, we don't put it on there, but you certainly can. But if you use just A and B, you've got to understand that if somebody says, no, I cannot come back on May 27th, because I am taking care of a family member who's been diagnosed with COVID, or for some other reason that's legitimate, then that triggers the ADA interactive process that we've been talking about previously. So you can't have a bright line of it just being A and B, yes or no. If it's no, and the reason is because they're making more on unemployment, then they can be terminated. If the answer is no, because of a medical situation, either for them or for a family member, then we're going to have to take a step back, and we're going to have to engage in the interactive process.
What is the greatest legal threat to a company as it brings its employees back to normal work? I heard Congress is considering potential immunity for companies in regard to their employees and customers. Is this going to happen?
Okay. The greatest legal threat, well, certainly you could have an outbreak of COVID that could affect business operations. You could have employees or customers who get infected and think that occurred in your workplace and end up suing. There are suits that have been filed across the country. And you could pull the trigger too soon in regard to adverse actions on employees. For example, if that company that we talked about at the very beginning had said, you're walking off the line, then you've abandoned your job, you're terminated. They would have had 30 some employees who immediately had a winning NLRA case, and any employment lawyer would take that case. So those are some threats. Congress is considering potential immunity legislation. I'm sure folks have heard about, there's round 4 is being proposed right now. And one group is saying that it's a precondition that for any additional money that's going to be expended, we're going to have some immunity for companies in regard to employees and customers. But the other side is saying, well, if you're going to have immunity, first we've got to have a governmental standard, an OSHA standard that companies have to abide by and provide safe workplaces for the employees. So that is more to come, to be determined. It is being discussed. I suspect there could be immunity to some extent, but it would probably be qualified in terms of you not violating certain safety standards. They're not going to let somebody just say, well, we're not going to have any PPE and not have a policy, and yet they're going to be immune. That's not going to happen.
The next question is, should we have employees and or customers sign a waiver to release the company from liability?
And I've been asked this question quite a bit. Employees, no. It's not worth the paper that it's written on. You can't have an employee sign away any right to workers' compensation before an injury has occurred, and getting COVID-19 in the workplace could be an occupational disease that is compensable under the Workers' Compensation Act. And you can't get an employee to waive a future employment type claim that hasn't come about yet or hasn't arisen. So that's not worth the paper it's written on. Customers, that's a different issue. You could have customers and patients sign a waiver just explaining the hazards of COVID-19. I would specifically name it and say that we're doing business with you, but only on the condition that you're releasing us from any potential liability. Now, is that worth the paper it's written on? Maybe. There are some courts that probably would enforce it, some probably would not. But to the extent that it is a deterrent for litigation, then for one person, then it's paid for itself. So it's not a bad idea. I'm not going out and recommending companies do this because it could be a bad PR look, but it's certainly something that you could do, and I don't see any reason from a legal standpoint that I would discourage it in regard to customers people outside the company.
can an employer use PPP proceeds to pay bonuses or hazard pay?
Okay, PPP is the Paycheck Protection Program, which is a portion of the CARES Act, which was essentially the most round three and of relief. And this is for employers who are under 500 employees that got these PPP loans. And if they do what they're supposed to do, they got 2.5 times a month's average payroll. And if they spend that money on the right things, payroll, utilities, rent payments or mortgage payments, during that 8-week period, then it can be forgiven. And you can only use 25% of it to pay the non-payroll portions. But so let's say we get to near the end of the 8 weeks and we need to use up more of that money for bonuses or get the payroll number higher. Yes, you could, the bonuses and hazard pay count, and but you can't take it out so that it annualizes more than $100,000 a year. So if you take $100,000, divide it by 52 weeks, multiply that weekly number times 8 weeks, it comes up to $15,384 and some change. You can't pay an employee more than that during that 8-week period. Otherwise, you can pay them, but the portion above that number will not be forgiven. And so you'll have to pay that back as part of a low interest loan. But otherwise, it can be forgiven.
And our last question that was presented in advance is, after the 8-week period for our PPP loan expires on June 19, can we lay off employees if the business has not returned to appropriate levels to justify keeping those employees? If so, can we do so immediately after the 8 weeks have expired, or do we need to wait until after June 30?
That is a great question, and frankly, would be an awesome law school question. And I cannot give an absolute 100% definitive answer on that, but our belief, based upon the guidance that we've seen so far come from the federal government, is that yes, you could do it, but I'd be careful. Let's say we've never laid anybody off as a result of COVID-19, and we were able to keep our employee numbers up because of the PPP loan. And now that the PPP money is running out, which it will start doing in early June for a lot of folks, then business operations may not justify having that level of employees. Our opinion is that you can lay folks off once the PPP period has run its course. However, if you did lay folks off as a result of COVID-19 and you brought them back after getting the PPP money, you may be better advised to wait until after June 30. And the reason June 30 is a magic number is that the PPP legislation says that if you did lay folks off, you have until June 30th to bring them back, and you will not be penalized for loan forgiveness purposes. So there's definitely a look forward period, at least to June 30th, in regard to employees who are brought back and from being laid off prior to getting the money. So if you fall in that category, out of an abundance of caution, I would suggest not taking any of that action until after the 30th, unless we get additional guidance from the government. And we do expect additional guidance maybe as early as tomorrow. Certainly there's still a good amount of time to go before folks' 8 weeks are running out. And so we expect another couple of rounds of guidance to come out from the government. For example, let's see, we just got something within the last couple of days from the government that said if your PPP loan is 2 million or more, you will be audited, and you'll have to make certain showings. If you're under 2 million, there is a presumption that you did need it. And prior to getting this guidance, there were a lot of folks that had some liquidity that were concerned that maybe the government would think they should not get the PPP loan due to their liquidity. And what the government has now come out and said is there's a presumption that you need, if you're below $2 million on your loan, then you needed that money. And so I think that's alleviated a lot of folks' concerns. And do we have any other questions in the chat room?
We do. So the first is, how do you recommend if an employee's job requires them to do home inspections and encounter individuals at home or in their apartment, and they refuse to go even if you require PPE? What if they get infected even though they're using the PPE provided?
Okay. I would, in that, and we've had a situation comparable to that we've advised the client on. And in that situation, again, it gets back to the same question as before. We provide some education and help the person see that here's what you're supposed to do. You can also require that the people that are in the home be out away from the person, that we social distance, and they are not present while the person is doing the inspection and doing what they need to do inside the premises. It could be inspecting, it could be people coming in and doing necessary repairs that tenants have requested. But we ask them to be out of the presence of the person so that they're not being exposed to them directly. They should be completely covered with PPE, including gloves and masks. And in that situation, there's no reason they shouldn't do that job. And if they won't do it, then you should find somebody that's willing to do it. If they get COVID-19, well, they certainly will most likely file for workers' compensation, and then that'll be up to your workers' compensation carrier to defend. Frankly, we don't know if they got it as a result of these home inspections or if they got it at the gas station when they gassed up last time. So that's up to workers' comp as to how they're going to defend it. But I would not let that stop me from conducting business.
The second question is, how can employers document compliance with temperature checks? For instance, how can we prove that we are doing this without creating records with personal health information?
Okay, great question. First of all, if you do create records, then that is considered personal health information, and it needs to be protected just like you would any other medical information relating to an employee. So that's number one. Number two, you do not have to keep a record of it, though. Frankly, you could just have people screened, and if as long as they don't have a high fever, then let them go. You don't have to keep an actual record. But if you do keep a record, it is a protected health. It is PHI, protected health information. So, for example, at our firm, we're not keeping records as long as the person doesn't have a fever. They continue. They do their job. And there's no record that's generated.
Thank you very much, Ken. We're almost right at the hour, and I do know that the RTAC ACC likes to end promptly at 1 p.m. for these events. So thank you so much, Ken. We greatly appreciate you speaking today. For those in attendance, following this webinar, you will be sent an email with a list of articles related to the issues that Ken discussed today, information about Warden Smith's Loan Maximizer Report service, and the link to sign up for our COVID-19 newsletters. We also will make a recording of this webinar available. As a reminder, North Carolina CLE accreditation is pending for this webinar. Warden Smith will submit accreditation materials for attendees seeking North Carolina credit only. If you need out-of-state credits, please email us at rsvp@wardensmith.com if you need a certificate of attendance and webinar materials to submit for out-of-state accreditation. Warden Smith and the Research Triangle chapter of the ACC appreciate you taking the time to join us, and we hope that you're able to take some of the information you learned today and apply it to your own business. Thank you very much. This concludes the webinar.